morning. Hi, I'm here with Barbara Zabawa. I'm Rebecca. I'm the community manager here at YourCoach, and we're just going to wait a minute or two for everybody to log in and join, and then we can get started. Oh, sunny side of Washington State. That sounds really good. And Brooklyn. Wow. Right. All right. I think we can get started. And oh yeah, Florida. So people keep joining. Let's just start so we can get to the good part. So hi everyone, I'm Rebecca. I'm the community manager here at YourCoach Health, and part of my job is to create wonderful resources for our coaching community on the YourCoach platform. So this is one of our wonderful events with our legal expert, Barbara Zabawa. And if you don't know YourCoach Health very well, we are an operating system for behavior change powered by health coaches. We are also an end-to-end practice management solution for all your health and wellness coaching needs. You can run your practice on the platform. You can accept payments, take notes, run live sessions, anything really that you need for your coaching practice. And thanks to our industry partnership, we also offer client opportunities and partnerships for practicing coaches on the platform. So if you need more information, please feel free to reach out to me or join our coaching community group on the platform. It would be lovely to see you. And without further ado, I would like to welcome Barbara Zabawa, who will be hosting this wonderful class about how to protect you and your clients, how to create contracts, legal agreements to make sure that your practice is protected. So Barbara, would you introduce yourself?
Oh, yeah. Hi. Thanks, Rebecca. Hi, everybody. Thanks for hopping on today's webinar. I am Barbara Zabawa. I'm a lawyer. I own and operate the Center for Health and Wellness Law. And you can learn more about my law firm at wellnesslaw.com. And I have been practicing wellness law, specifically for 8 years, but I've been a lawyer since 2001. So 21 years, I guess. And I also have a master's in public health. And I teach at the University of Wisconsin-Milwaukee, health law and compliance and ethics courses. And I also have my own clothing line. So I'm an entrepreneur, like many of you who are in coaching. That's the typical model, is you're hanging out a shingle and providing coaching services to clients directly and charging them a fee. And so one of the key components of that coaching relationship is having a really good contract. And that's what we're going to talk about today.
Amazing. I'll just leave you to it, Barbara. Thank you so much. It's always lovely to have amazing entrepreneurs, and you're wonderful. So I will drop all your contact info in the chat, and have a really great session.
Thanks. I'm going to share my screen so you guys can see my slides. So I'm going to guess that you can see my slides now. And let me just make sure. Yes. Okay. So you guys have a great group right now. That's awesome. From all over. And let's see, let me just start. Well, I'll leave it on this so I can see what's up next. So I understand that some of you submitted questions in advance of the webinar. And I actually structured my slides and presentation around those questions because I want this to be relevant to you as coaches. And I believe I've given a webinar about more general contracting law to YourCoach in the past. So this one's going to be much more narrowly drawn to what is important for you as health coaches to know about contracts, specifically contracts with clients. So, oh, excuse me while my dog barks. I apologize. So the agenda that I want to cover today is key factors for contracts, particularly contracts with clients. But contracts come in all kinds of forms and covers all kinds of relationships. And so if you guys have questions about some other type of contract, such as independent contractor agreements or contracts with corporations, maybe you as a coach want to deliver services in the workplace or for some major company, we can talk about those as well. Then I will cover templates versus personalized contracts, because that's an important question. And I want to give you the pros and cons of each. Then I'll talk about updating contracts. So if something changes, what do you do? Breach of contract, what that entails, what that might mean, and amending contracts. So it's a little different than updating contracts, but there can be some overlap. Okay, so let's start first with key factors for contracts. And I should mention, if you guys have questions, it seems like Rebecca might have already said that you can please drop the questions in the chat or the Q&A, but it looks like we're just using the chat. So go ahead and write your question in the chat box, and I'll try to get to them for sure at the end. And if I see any as I'm talking, I'll try to answer them as I go as well. Okay, so one of the key things, first things that you should have as a health coach is a contract for services with your clients. This is a key document. As I tell my clients, it sets the proper expectations between you and your clients. So it kind of gives you some rules to operate within, and your clients some rules to operate within. And that is really important, from not just a smooth operation of your coaching practice, but of course, from a legal standpoint, setting up the expectations in a written form is so important, because you then have a tool that you can use and reference should any confusion be either between you or your client ever arise. And that, as a business owner, that is likely to happen on occasion. I think an important point to remember is that you don't need it in writing. In fact, most contracts don't need to be in writing to be enforceable. But we usually think that contracts should be in writing, and some contracts do have to be in writing in order to be enforceable. The typical contracts that have to be in writing are those that can relate to real estate transactions. So purchasing property, those have to be in writing. Services for more than a year have to be in writing, and purchases of goods, I think, for more than $500 must be in writing. But otherwise, if there's an agreement between two parties that don't fall within one of these categories that need to be in writing, if it's just a verbal agreement, and there's all the elements of a contract are met, that is, there's an offer, there's acceptance, there's something of value that's being exchanged between the two parties, and that the underlying agreement is legal for a legal subject area, and the parties are competent, then you could have a valid contract, even though it's not committed to writing. But why do we want it in writing, even if it doesn't have to be? Well, because then it's less likely that there will be confusion as to what the parties agreed to. Because if you don't document what you are agreeing to, one party might remember the conversation very differently than the other. And so memorializing your agreement in a written form where both parties have read through the document and signed on the dotted line after reading through it is going to relieve you of having confusion between the parties, because you'll have the words on the page that you can reference if any confusion arises. So what should a good coaching contract with your clients have in it? Well, first of all, I suggest that it be in writing, and preferably like a document and not an exchange of emails, because that could be a contract too. If you offer to provide coaching services via email, and then the person, your client, responds via email, and they pay you, you could use the emails exchange as a contract, but it's better to have it all laid out in like a Word document and then PDF that the parties can print out and read and sign. You can have e-signatures, those are valid, but you might want to have them sign as the handwritten signature too. So, but inevitably they should be in writing, just because, as I mentioned before, it will reduce the likelihood that there'll be confusion as to what was agreed to. Then your coaching services contract should explain what you are providing. You don't have to go into great detail as to the services that you're providing. But generally explain the kinds of services, like if you're doing nutrition coaching, say that you'll be doing nutrition coaching, and if you're going to be incorporating some yoga into your practice, say that. Just identify the services that you are planning to offer so that the client knows what they're paying for. It's really good for them to know what they're buying, and so it's your obligation really to kind of list for them the services. Again, you don't need to go into great detail. In fact, too much detail could create obligations that later you might regret. But enough detail to give the client an idea of what the services you're providing are. And then you should also disclose what you're not offering. Now, by that, I mean, you should, as a coach, and I've said this in numerous webinars, and perhaps some of you have been on those webinars, you're not regulated by any state or federal authority in the United States. There is no regulation of health coaches. And so that can be a blessing, and it can also be kind of a problem. It's a blessing because you don't have to worry about getting any licenses and having to worry about getting a certain amount of continuing education to maintain your license. And that also means you don't have to worry about where you practice, because you don't have a license that is telling you can only practice where your license is good to practice. But because you don't have a license, that means you can't practice licensed professions because you don't have one. So if you are tempted to give advice, which I think most coaches now understand, that you shouldn't be diagnosing or treating underlying medical conditions, as soon as you start talking about or narrowing your coaching practice to certain people with certain medical conditions, that can get a little bit more risky, because there may be some expectation that going to you as a coach, if you specialize in diabetes or whatever it might be, that there would be some relief of your diabetes, some cure of your diabetes And that can cause problems, because that is the role. Curing diabetes, treating diabetes, diagnosing diabetes is all in the role of a medical practitioner, a physician, and maybe some other types of licensed providers. And so in your contract of services, you should be disclosing very, very clearly that you are not functioning as a licensed healthcare provider, a licensed psychotherapist, and any number of types of licensed practitioners. The typical ones that coaching bumps up against are physicians, medical doctors, dietitians, and mental health therapists. So you should be telling your clients that you are not those licensed professionals, and they should not be expecting those types of services from you. And in fact, they should maintain relationships with licensed professionals. So you should have language in your services agreement that clearly outlines that expectation that of what you are not doing as part of your practice. And then it's also a good idea to maintain a really good, productive client relationship, to have language in your services agreement that outlines what the client should be responsible for: showing up on time, following through on, homework that maybe you assigned them, paying their bills, of course, and that's a big one. And that way, they have a good understanding of what you're expecting from them. And if you're doing group coaching, that would be a good place for you to have some language in your coaching services agreement about expectations when working with a group. So, and that's both for the coach and for the clients who are in the group coaching session. So the language might say that the coach will do their best to maintain some privacy and security around what information is shared with the group participants, but that the coach can't necessarily control what group participants do. And so that, group participants shouldn't hold the coach responsible if one of the group members goes rogue and starts spreading information, sensitive information that they learned or gleaned from a coaching session. At the same time, the language in your contract should also tell the group participants that there is an expectation of privacy, and that what's learned and shared in the group sessions should be maintained it should be confidential. And if a group member fails to adhere to that expectation, that the coach retains the right to get rid of them, to expel them from the group. So that language, I think, is also very important to have in your coaching services agreement. Another thing that you want to have in your agreement is language that you're not guaranteeing any results. You might have real good faith in your abilities as a coach, and you should, but at the end of the day, you do not want to mislead clients into thinking that if they see you as a coach, that this is what's going to happen, because lots of things intervene and you can't control all of it. So covering your butt by having language saying that you're not guaranteeing any results, I think, is an important provision that would be in a really good coaching services agreement. You'll also want to explain payment terms, because obviously you cannot have an enforceable agreement unless there is consideration. So you're giving services in exchange for something, usually payment. So what are those payment terms? How often are you going to charge? How much are you going to charge? How will they pay their bills? Are you accepting credit card? What about insurance? A lot of times people, because you're in the health space, there's sometimes this confusion that, you might be covered by insurance. So having some language about that, you don't take insurance, you're not responsible for any insurance claims being made, that can help clear up some confusion. it's a good place. The coaching services agreement is also have an explanation of your scheduling and cancellation policy. And maybe you just have a policy that you give them a separate document, but you could reference it as part of the agreement, and that the client agrees to abide by this cancellation and scheduling policy. Or you could have it right in the coaching services agreement as to how they can schedule appointments with you, when can they cancel, how far in advance must they cancel before they incur some sort of financial penalty for canceling too late. And those kinds of things should be in your services agreement. You should also talk about your privacy protections. Like we talked about it in terms of the group coaching context, but even outside of a group, just the one-on-one coaching sessions, you should have some language explaining what your privacy protections are, and that you value privacy and confidentiality. Sometimes people mention HIPAA. Typically, HIPAA does not apply to the coaching relationship. So, whether you want to mention HIPAA, even if you're voluntarily complying, you want to make that very clear that you're voluntarily complying, and you're maybe adopting some HIPAA standards. People take comfort in HIPAA. It's familiar. It kind of is the gold standard of privacy and data security protection, but you also don't want to, give your clients the expectation that you are subject to HIPAA and must comply. So that you're going to want to have language that just explains that you value their privacy and you do what you can to protect their data that they're sharing with you. You might want to reference your privacy policy that you have for your website, but you're definitely going to want to address that issue in your services agreement. You might also want to include liability waivers. In fact, I think that's a good idea. So if something does go wrong with the coaching relationship, you want to be able to protect yourself and say that, that by entering into this agreement, the client is agreeing not to sue you for things that might go wrong, that they're taking on this risk of a coaching relationship. And so they sign off on their right to sue you. Now, whether a court of law would actually uphold that liability waiver is another question. And sometimes they aren't upheld, but having that language in there certainly can deter your clients from seeking legal action against you. So it still might be a good idea. And then, of course, there should be a signature line for both you and the client, and you can use e-signatures. That's totally fine. So if it's part of like a platform and it pops up and they read through it and they e-sign, that can be one option that you can use to distribute the agreement. If you do have it as a pop-up, they should be able to print it out or go back and reference it, because you don't want to mislead them and not have that agreement available to them if they later want to reference it. And then it's a good idea to have as part of your agreement how the contract may change. If you decide to update your fees or change your policy on scheduling or cancellation, you reserve the right to do that, and this is how that will be done. So having that kind of language is important too, so that clients can't hold you indefinitely to terms that maybe no longer work for you. So that is that section. Now I see there may have been some questions that came in, so let me see what I missed. Is services agreement the same thing as a contract? Yes, so agreement and contract are used synonymously. So agreement is just another word for contract. So services contract. And it just is a matter of preference of which word you use. I didn't see any other questions. So I will move on to the next topic, which is, as I mentioned, for a contract to be enforceable, it has to meet certain elements. There has to be offer, there has to be an acceptance, there has to be consideration, exchange of something valuable between the parties. It has to be made by competent parties, and then it also has to be legal. So meaning the underlying subject which you're contracting has to be a legal subject. It can't be an illegal event. So like the biggest one I use is you can't contract with somebody to have them, execute someone, murder someone. Murder is illegal. You can't have a contract for murder. It won't be enforceable. Where this comes up in the coaching context is if a coach is having a services agreement or contract that is promising to do things that the coach is not legally authorized to do. So if the coach is their services, as they're describing their services, which they should as part of their agreement, is describing services that would only be allowed to be performed by a licensed physician, for example, then one could argue that the underlying subject of the contract is not legal because the coach isn't licensed to practice medicine. So they can't diagnose, treat, cure, prevent certain diseases. But if that's what they're saying that they're going to do as part of their services in the contract, that could make it an illegal contract. And therefore, if it's illegal, it's not enforceable. So, if someone decides they're not going to pay you, your client decides they're not going to pay you, and you try to point to the contract saying, well, no, it says right here that in exchange for my services, you will be paying me X amount every month, and they still refuse to pay you, and you try to take them to court for a breach of contract, there may be a decision by the court, well, no, this contract's illegal because you can't provide those kinds of services. You're not licensed to do it. So that's why it's really important when you're describing your services to make sure you're doing it in a way that won't get you accused of entering into an illegal contract. That's what I really wanted to impress upon you here. Which leads us to templates versus personalized contracts. So there are templates out there for coaching contracts. And typically buying a template is less expensive than having a lawyer draft one for you. So that's one of the big upsides to using a template is cost. And you get to download a template and fill in areas as you wish, and then you're off and running. Whereas if you work with a lawyer, it might take a little longer because they're trying to understand what you're doing, and then they're trying to craft language that is appropriate for your coaching practice inside of a contract. So it might take longer, and because it takes a little longer, it's going to cost a little bit more money than a template. But on the upside is that, especially if you use a lawyer who's familiar with health coaching practice and the limits within a coaching practice, the legal limits, the language that's going to be used, especially for describing your services and other provisions, is going to make sense and have less chance of not meeting legal requirements for a contract. So if you download a template and you're using your own language to fill in the blanks of the template, you may not be aware, or you might be choosing words that could present more risk than you realize. Whereas if you're working with a lawyer, they know the risks and they can choose language that works for you that accurately describes what you're doing, but doesn't present the same kind of legal risk. So it's basically, you don't know what you don't know, right? So those are the pros and cons of using templates versus personalized contracts. And so the more elaborate you want to be in your contract, the more it might make sense to use a personalized approach to it. And I don't really know when a template that has basic provisions could be sufficient, but it could be sufficient. It just really depends a lot on your comfort level too, as a coach. So what is your risk tolerance? If you feel really confident in your knowledge and abilities to fill in blanks, and pretty confident that what you're doing is not going to infringe on some licensed practice area, then you're probably fine using a template. But if you have any doubt at all about what you're doing and how, if it's going to get you into trouble with a licensing board, for example, you might want to consult a lawyer and have them walk you through it. Now, the best of both worlds is having a template, but then access to a lawyer to help walk you through how to fill it out appropriately for your practice. That really is the best of both worlds, because you're limiting your costs, but you're still getting some legal insight from an expert. And I also say that be careful if you are going to go down the template route, that you really understand what that template is for. And I'll use an example of how you can get confused with templates. So I know a lot of health coaches go to different platforms for their virtual coaching practice. And sometimes those platforms will offer templates as part of the package that you can download. And I know one coaching platform had offered a consent form as part of the virtual platform package. And so I think one of my clients had downloaded this consent form and they sent it to me and asked me if this was sufficient. And in their mind, they thought the consent form was what we're talking about with the coaching services agreement. So you're getting your client's consent to provide coaching services. When in fact, the consent form that they sent me that was available as part of this virtual platform package was a consent form about divulging data. So the client was consenting to use and disclosure of the data that they were filling in on the platform. It had nothing to do with the services that the coach was providing. So word of caution, make sure you understand, if you're going to use templates, that what the template is really intended to do, which would require you to really read through it and understand what it is intending to do, because you may be mistaken on what it was intended to do. And you may think that, oh, I have this consent form and I have my client sign it and we're all good. And when in fact, it really isn't doing what you thought it was doing. So just be aware of that. Okay, I see another question came in. I'll just look at that. Would you still recommend creating a contract if you're offering your health coaching services pro bono or on a donation basis? Yes. I mean, just because you're not collecting a fee, obviously you're getting some benefit from the relationship, or you wouldn't be doing it. Maybe it's training or some other benefit for your coaching practice. Just because you are not collecting any money for what you're providing doesn't mean that your client is going to understand what their role is or what your role is. So they, if they don't like what you're doing, or they think that you hurt them by something that you said or did, or you misled them in some way, they could still sue you. And so having a coaching agreement that, has the liability waivers and sets up the proper expectations that you can point to, if they get mad at you and say, hey, I thought you were going to do this, and this is all you're doing for me, you can point to the language in the agreement and say, no, this is what we agreed to. Let me show you where in the agreement that it says, this is what I was planning to do for you, and this is your obligation under the agreement. So that can usually calm people down, because they realize, oh, there's, what was in my head is not the same thing as what I signed in the agreement. So yes, I absolutely think you should still have an agreement, even if you're doing it free of charge, your services. Okay. The next area I want to talk about is updating contracts. So you might have this great services agreement, and it might do its job for a few years, but then you realize, I want to change my fees, or I want to maybe scale back and not do as many appointments, or, just restructure how you're doing your coaching practice. And you realize that your services agreement doesn't really reflect how you want your coaching practice to look now. So you need to update it. So that you should update, the provisions in your contract that need to change based on what you want it to look like now, and then have your clients sign that new agreement, your existing clients, and then of course any new clients will sign the new agreement. Hopefully your agreement allows you to make changes to the agreement. But if there's no language, you have the right to make those changes. And of course, your clients have the right to not accept those changes. So that is completely up to you. So if you're facing a situation where you increase your fees, for example, and the client doesn't want to sign off on the new fee structure, that's their right, just as much as it is your right to change your fees. So there has to be an agreement to enter into that new contract. And then if you want to amend a contract, so let's say this is like similar to updating, but not really. So an update usually is unilateral. You as the coach decide that you're going to change your fees or some aspect of your coaching business, and which is your right to do. And so you need to update your contracts to reflect those changes. Amending a contract usually happens when, with existing clients, what was in the original contract isn't working in the relationship anymore, and you as parties to the agreement decide that you need to change some of the terms of the agreement, maybe like your cancellation policy or something along those lines. For this particular, amending doesn't necessarily have to be across the board. It could be with a particular client. You need to make an exception for a certain client because of special circumstances. So a good contract services agreement will say that no amendments to an agreement can be made unless both parties mutually agree in writing. And so if you both agree to amend a provision of your particular agreement, you would create an amendment. You would reference the section of the original contract that you're changing and have a new language in a new document that references the old document, and then you both sign the amendment and attach it essentially to the original agreement if it was in paper form, for example. So that's something that you can do, but usually it requires both parties to agree to it in writing. You could do it via email too. You don't have to have a separate document. You could say in an email exchange, we're both agreeing to amend section 3 of the original agreement to instead of stating what it says in section 3 in the original agreement, this is what we want section 3 to state, and then write what you want it to state, and then have both of you agree via email. Yes, I agree to that. Yes, I agree to that. That could effectively amend your agreement too. But you want to make sure that you are properly referencing what is being amended. And so you might want to work with legal counsel in doing that. Again, you don't need to, but it might help it be more smooth in the amendment process. So what we're trying to avoid with a good contract is set proper expectations so both parties know what is expected of them, so that neither party breaches the underlying agreement. But if that happens, if a client doesn't pay, or the coach doesn't deliver the services that they promised, that could be constituted as a breach, which can lead to a legal action. It had nothing to do with the licensing board, but they could bring a lawsuit in a court of law. Or if you have an arbitration provision in your services agreement, then they have to go to arbitration. But what would happen is if there was a successful breach of contract action, there could be money damages that are having to be paid out, or there would be a specific performance requirement where the other party had to perform what they were supposed to and under the contract as agreed to. But we're trying to avoid those as much as possible by writing good contracts to begin with, and hopefully setting proper expectations so that there's no temptation of breaching the contract. But should those types of actions occur, there could be monetary damages and specific performance that's required of one of the parties to fulfill their end of the bargain. Okay, let's see. I think there was a couple more questions that came in. Sorry if I missed this, but what if the client doesn't agree to an amendment you feel you need? Is there a way to cancel the original agreement if needed? And is there language to put in the original agreement to help avoid this situation? Yes, I mean, you would have there should be language about if there's a failure to pay, or if one party does not fulfill their end of the bargain, that the party can terminate the agreement and seek other remedies. But yeah, I mean, if no one has to agree to an amendment, especially if there's language in there that requires both parties to mutually agree to an amendment, and one doesn't want to, then there's not going to be an amendment. And so then, yes, you would terminate the relationship. Second question is, I live in a red nutrition state. What are some of the legal requirements and considerations I have to watch when practicing? Well, the big one is that you can't usually you can't call yourself or identify yourself as a nutritionist or dietitian, depending on the state, what language they use in their licensing statutes. And you have to be familiar, basically, you have to be familiar with your state's licensing statutes and regulation around the delivery of nutrition counseling and dietary advice. What is allowed by people who don't have the license and what is not, and then structure your coaching practice around that. So that's what you need to be aware of. Those are all the slides that I had for you all today. Let's see, another question came in. If you do want to reach out to me, here are the many ways you can reach out to me on social media and email and my website, which I just revamped. So take a look. But the next question that I see is, what are the legal requirements for certain assets, like referring to YouTube videos, clip art, using downloadables with clients? Do I need to disclose this in advance? I guess, are you asking about intellectual property? Or are you asking, I mean, so if you're using other people's work, you can put in your services agreement some language saying that you're not responsible for what third parties say or do. But the fact that you're actually using it and referring them to it can create some sense of endorsement of what they're saying. So I guess it would depend on the context. Like a lot of people will have on their website links to other resources, other, videos or articles, and many times there will be a disclaimer on the website that you are not responsible for the content of these other third-party resources. You're just providing them for educational tools only. And so that would be one way to handle that. I see another question that came in. I have more than one license degree. Do I need to take this into consideration when crafting a contract? Yeah, that's a great question, because a lot of people who practice health coaching do have a license. They come from a licensed profession. I've had clients who were physicians, nurses, chiropractors, other kinds of licensed providers, mental health practitioners, psychologists, and licensed professional counselors who want to deliver services beyond their state where they have a license, because they don't have a license in multiple states, and I don't recommend it to have licenses in multiple states. So coaching is an attractive option for them. But they don't want to disguise the fact that they have this professional training. They want to use that to help differentiate themselves or give some credibility to their coaching practice. And so when, promoting that or describing your background, it's really important to have language that properly identifies you as having this educational background, but that you're not practicing as that kind of professional. And that can be in your services agreement. It should be on your about page of your website, and any other promotional materials, so that it's clear that you are not practicing, because you have a bit more risk in being perceived as practicing that licensed profession if you actually have the degree and are licensed in one state. And so you need to be very clear about your role anywhere where you're talking about what you do. Can you share some examples on malpractice insurance? Yeah, the coaches have a few options for malpractice. On my new website, there's actually a training video that I have on malpractice insurance, where I share some ideas on what types of insurance you might want, and give you some companies that I've suggested you look at. I don't have any relationships at all with any of the coaching insurance companies out there. There's about 4 of them, and I don't really even have them committed to memory. Yeah, I have given clients of mine, suggestions about the types of insurers you might want to check out, and see which one makes sense for you. Any other questions? Well, if not, I want to thank you all again for listening, and good luck with your coaching practice. And yeah, if you need anything, you can follow up with me, and again, in any of the number of ways on this slide.
Thank you so much, Barbara. This was super informative. I mean, I'm sure people are left with a lot of questions. So if you have any questions, as Barbara said, you can reach out to her via any of these platforms on the screen, or if you forget it or didn't take a screenshot, you can also reach out to team@YourCoach.health, and then we'll help you reach Barbara. So thank you so much.
There was another question, Rebecca, that came in.
Let's hear it.
Are there certain standard contracts? But I mean, I know the contracts we use at my firm, there is some bias I think are pretty good. Just make sure that if you are going to try to use one, that they have the elements I talked about at the very least. And yeah, you just want to make sure you set the proper expectations.
All right. So if there's no other questions, once again, thank you so much, Barbara. I will drop a link into the chat. This is where you can reach us here at YourCoach. As I said, we are an operating system for behavior change powered by health coaches. And we are also an end-to-end practice management where you can manage your health and wellness coaching practice. You can also upload contracts to the platform and your clients can sign it within the platform, so you don't have to use a third-party electronic signature or any other thing. So thank you so much, Barbara, and visit the link below and follow us on social media because we'll have some exciting events coming up and webinars. So it would be lovely to see you there. Thank you so much.